The world has certainly gotten more complex, and in connection with intellectual planning, both the legal and the tax side of that, things have changed quite a bit. The things that we were able to do 10, even 5 years ago, no longer possible, at least not with the tax benefits that we used to create in terms of moving IP across borders. As Stephen mentioned, we're going to be going through 4 case studies. We thought a case study approach might be more interesting for you, and we'll try to tease out some of the principles and the takeaways from each case study. And I'll pause at the end of each case study. If there's any questions or comments from the audience, we'd be happy to entertain those. I'd like to just clarify, we're not giving any legal advice or tax advice this morning. The work that we do is very factual specific. The devil's in the details. We'd be pleased to speak with you about any of your situations, but this is just for general conversation, not intended as legal or tax advice. With that, Jamie, would you like to introduce yourself? We'll just go down the line.
Sure. So I'm Jamie Van Habib. I'm a manager in transfer pricing. And for those of you not familiar with what transfer pricing is, it's the pricing for the sale of goods or services or tangibles from one related entity to another. And it's a tax problem because you're effectively moving profits from one related entity to another. So my background is economics and finance, and happy to be here. Thank you.
Kenneth Barwanto. I'm a senior manager at our international tax practice, and I also lead the international tax practice for our Orange County office. I've been with RSM for 5 years now, but I used to work at Big Four. I actually started my career with KPMG in Singapore before I moved to the States about 9 years ago. Our practice really focuses on U.S. companies going abroad and also foreign companies going into the U.S. So we've got a lot of Canadian companies actually that are our clients investing in the Orange County market.
Morning, I'm Vlad Teplitsky. I'm a partner here at Knobbe Martens. My technical background is in electrical engineering, computer science. I worked in the industry for about 5 years, and then I decided to completely switch careers. I attended law school, and now for about 14 years, I advise clients in the areas of obtaining patents and defending patent rights.
I'm Harnik Shukla. I grew up in also Scarborough and went to school at University of Toronto for my undergrad and master's. And then I was too tired of the Canadian winters and came out here for law school at UC Irvine. So I've been in California for more than 10 years. After UC Irvine Law, I joined Knobbe as a summer intern and then as associate, and I'm now a partner. I remember in 2015, I was still an associate when we had our first event here. So it's been a good journey.
All right, with that, let's get into it then. So our first case study, and this is one we used to see all the time. We've got a U.S. company, Gamers Inc. They've developed, it's a video game studio, and they've developed a video gaming play on mobile devices. And the CEO tells us that he heard it's a good idea to transfer the IP rights, so the source code, the themes, the characters, to a Cayman company. And this is just a shell company. There's no substance there. Basically a PO box represented by a Cayman law firm. So the first question, and this would go to Knobbe, what if the IP was valued at something nominal, such as $1? What are the IP implications for doing that?
It would not be good for the IP, and the reason being, of course, as you might imagine, valuing the IP at $1 would create some serious problems in the future should that IP ever be enforced. Clearly, if a fact comes out in a lawsuit that IP was valued at $1, it would be very difficult to seek, large damages in the range of millions or maybe even tens of thousands. I guess this, just as an aside, this probably this example and this question underscores the tension between the desire to value the IP at a lower price for tax reasons, and then the desire to value the IP at a much higher price for reasons of later enforcement.
So how about the tax consequences? And Jamie, maybe you could take this one and talk a little bit about the arm's length standard in your comments, if you would.
Sure. Yeah. So the at the heart of all of transfer pricing is the arm's length standard, or the rest of the world might know it as arm's length principle. And effectively, what it says is what would the price be between two unrelated parties? And because if you think transfer pricing is the focus of intercompany transactions, one entity and another related entity. So there could be a tendency, I guess, perhaps to want to cheat. So the transfer pricing rules don't allow that. And so at the heart of that is the arm's length standard. Now, to figure out how that pricing, how the profit component would be allocated between the groups, you focus on the functions, the risks, and the assets of each of the parties. And so there's an analysis that's done on both sides. And with respect to intangibles, there's a focus of, on the so-called DEMPI functions. This is, development, enhancement, maintenance, protection, exploitation. And this is at the heart of the transfer pricing analysis, is determining who is performing these DEMPI functions, who has control of the risk and the assets. So in this particular case, we've got the U.S. and Cayman, and there's no substance. All the substance is on one side. So transfer pricing rules would basically dictate that all the profits should really be with the U.S. And so a structure like this would not be advisable at all. And it would be very high risk, especially from the U.S. perspective.
Yeah, and this is one, again, we used to see 15 years ago, but we certainly don't recommend any of our clients to do this. And this is what we call a round tripping situation, where the IP goes out and then the rights come right back to the U.S. Terrible optics on that from the IRS perspective. There's just no business purpose generally when you've got a round trip of the IP. Kenneth, if we structured the transaction in different ways, maybe a capital contribution instead of a sale, could we get around some of these valuation and tax problems?
No, not necessarily. When you've got a contribution of an IP right from, for example, a U.S. company or perhaps even a Canadian company to a foreign company outside of the country, whether it's a contribution or a sale, the IRS in this case, they would still expect the transfer to be taxable at the arm's length value. So whether you contribute it as capital or a sale, it will generally give rise to the similar tax consequences here in the U.S. And tying it back to what Jamie said earlier about the transfer pricing. So when you're transferring the IP, it needs to be valued. It needs to be arm's length. It needs to be what you would sell the IP for to an unrelated party. And any gain that you make with respect to that IP, so whatever is the market value and then however much money you've invested in that IP, that's taxable in the U.S. at a 21% rate.
Okay, great, thanks. Any other comments, Vlad or Hardik?
Not on this.
Okay, let's move to case study 2. So case study 2, same fact pattern, but instead of a shell Cayman company, the offshore company is a real company. In this case, it's an Irish company. It has employees that are doing research and development work. The U.S. company's software engineers collaborate with the Irish company's engineers, and the two companies share costs of development of the intellectual property. The resulting worldwide IP rights from the collaboration are owned entirely by the Irish company, and the corresponding U.S. IP rights are licensed from Ireland to the U.S. So we've already discussed about the transfer out from the U.S. that would be taxable at fair market value. But in this case, we've got a few more complexities. Knobbe, how about employee agreements and what else is critical in this situation?
But it is very critical. So ownership diligence is extremely important, for IP perspective. Oftentimes, many of my small clients are surprised when I'm asking them for their employee agreements and the consulting agreements. And it's like, well, why is my IP lawyer asking about all these HR details? But that's where you would find, hopefully, a clause that assigns the IP rights from the employees or consultants to your company or whatever the holding company is for the patents. If there isn't any assignment clause. The way it works by law is that if you have conceived of an idea, you're automatically an inventor. That's by law. Or, for respect to copyright, you're automatically an author. So without any agreements, like in the employment agreement, the magic language is like, I do hereby assign. So that's a present assignment transfer. So anything you invent in the course of your employment gets automatically assigned to the company. So we need to make sure that between the US company and the Irish company, all the employment agreements are flowing, the ideas, the patents, copyright, all the IP is flowing to the right company. And then there will be the intercompany transfer as well between the US company and the Irish company. So all these agreements need to be made sure they're tight. There are times when, for example, if the Irish company is to assign to their, all the rights are flowing as correct ownership. The other situation, and I wanted to bring this up because I've noticed lately many of my clients where they're having their R&D done outside of the US for various reasons. One of my clients, their primary R&D center is in Sweden, and the CEO is in the US, and they do a lot of sales and everything in the US. Recently, they had to file a patent lawsuit against a competitor. And I think most here know that you could file a lawsuit in a federal court. But there's another avenue for filing a lawsuit, and that's at the International Trade Commission, ITC. And that helps you block importation of products. But to get there, you need to show that you have a domestic industry that's being harmed. But if all your R&D and manufacturing, substantial amount of work is happening outside of the US, then that avenue is closed. So whenever you're thinking about these like cross-border transactions, the location of R&D, also think about like whether you're closing another avenue to stop your competitors from coming into your space.
Excellent, thanks. So Jamie, different, a little bit more complex here. There's real activities going on in Ireland. There's some collaboration. The value of the IP is being enhanced in Ireland. It's not that round trip situation we were talking about in case study 1. How would you organize things under a kind of a developer assister model?
So in this case, all the IP would be held in Ireland. And if the U.S. is providing a service, then the U.S. would be charging a service charge to Ireland. And the way that that's measured is just looking at the service costs that the U.S. is incurring, and then would be charging that over to Ireland. And that amount would have to be arm's length. And so it's important that in most of the structures, for transfer pricing, is that whoever holds the intangible property tends to they earn the residual profit from the group, whereas the other entities that were within the group are going to be earning what we would call a routine return, or a return based on a simple function like a service or what have you.
Yeah, it's interesting with transfer pricing. What we're really talking about is dividing up the pie. The pie is your global profit. And Jamie and his team slice and dice the pie to ensure that each party, each member of the group gets their fair share of the profit. We don't create profit in transfer pricing or eliminate it. It's just an allocation methodology.
And just to add to that, again, the focus is always the functions, the risks, and the assets. And that's at the heart of every transfer pricing analysis.
I remember that because it's far out, FAR, functions, assets, and risks. That really drives the profitability of each entity in the group. So we talked about developer assister. Another model would be a qualified cost sharing arrangement. With the developer assister model, you've got that license of US rights coming from Ireland back to the US. Some countries, there could be some withholding, some tax consequences we don't like. a way to get around that is with a cost-sharing arrangement.
So with a cost-sharing arrangement, it's a co-development arrangement between two entities in different jurisdictions, and you effectively split the cost of development, and that could be related to R&D or marketing, and but those costs have to be arm's length. So if one is performing more marketing or one is performing more R&D, there would be cross-service charges. The profit at that point would just be whatever each sells to their third parties. So, but the costs would be split, and again, that has to be arm's length. The maintenance of this would be a cost-sharing arrangement is challenging because it's usually heavily documented, and again, focusing on the functions, risk, and assets of each entity. And on an annual basis, these transactions need to be tested, and as well as the initial value of the transfer of the IP moved to Ireland, that also would need to be tested on an annual basis. So it's definitely a big step for most organizations, and definitely needs to be considered carefully.
Yeah. So the qualified cost-sharing arrangements really stem from the age-old situation of two farmers that share in the cost of building a fence between their two fields. It's a common business arrangement, and qualified cost-sharing arrangements kind of recognize that and embrace that philosophy in the context of intellectual property planning. But as Jamie mentioned, heavily regulated. You have to disclose your tax return every year, and it is a big step. Kenneth, could you tell us a little bit about the knowledge development box and some of the other IP development incentives around the world?
Yeah, sure. So the knowledge development box is basically a tax incentive offered by the Irish government. So to the extent that you have intellectual property in Ireland and you meet a certain number of headcount, and sometimes it could be other requirements as well, like revenue amounts, you could qualify for this knowledge development box that basically reduces your tax rate. The Irish tax rate is 12.5%. Under just regular Irish trading profits. But to the extent that you qualify for this knowledge development box, your Irish income would basically be taxed at 6.25%. That is, so half of the statutory tax rate in Ireland. There are other countries as well that have similar regimes. For example, Switzerland, they have a pretty significant tax incentive for shipping IP there. Netherlands does as well. The UK did, but I recall that from a few years ago, it wasn't as lucrative anymore. And there are obviously some other Asian countries like Singapore doesn't really offer incentives based on a certain structured requirement. Typically, it's more of a negotiation that you do with their economic development board. But these incentives do exist across the world, and it's pretty common for large companies, especially, or even mid-sized companies, to actually want to pursue them to the extent that there's a good business reason for actually moving your IP and building some substance in the foreign country.
Yeah, usually to qualify for these IP boxes, you need real employees, warm bodies in country doing real R&D work.
Yeah, and it does actually align with what Jamie mentioned as well about there being DEMPI functions in a country, right? You want an IP holding company that doesn't only just own IP, it actually has people there doing stuff. So to the extent that you meet these DEMPI requirements and you meet the other requirements as well in these foreign countries, you should try to take advantage of these various incentives across the world.
Yeah. So even if things work out beautifully, if the IP planning works out exactly, we've got the facts just right, it's a perfect fact pattern, we're able to move the IP offshore. Many countries, US included, have tax laws now that take a lot of the fun out of the game. Commonly referred to as anti-deferral, US subpart F and guilty, but Canada has its own CFC rules. Most other countries do as well. Kenneth, could you talk a little bit about the anti-deferral rules and how those operate?
Sure. What that basically does is this was primarily introduced in the 2017 Tax Cuts and Jobs Act. There's a new provision called GILTI. It's called Global Intangible Low Tax Income. What guilty basically does is, even if you structured your business in a way that would avoid the old anti-deferral regime, which still exists, by the way, called Subpart F, what guilty basically does is, as a U.S. company or as a U.S. shareholder, if you own a company that you control outside of the U.S., you actually are required to pick up all of its income, most of its income at least, inside your U.S. taxable income as well. So, for example, here, if you've got a U.S. company that's got an Irish co, and Irish co does all the IP development, sells all the profits, sells all the products outside of the U.S. to foreign customers, the U.S. company would still need to pick up the Irish company's profits into the U.S. company's taxable income. So even though the profits really haven't gone back to the U.S., still stays in Ireland, you're still subject to U.S. tax on Ireland's profits. The good news, though, is that as a U.S. company, you are, as a C corporation, you are entitled to certain deductions and credits. So usually, if everything works out well, your effective tax rate in the U.S. would primarily be about 13 to 14%, but you can usually utilize the taxes that you paid in a foreign country to kind of offset those taxes in the U.S. So if you're able to get to that 13 to 14% answer, that's usually the best that you can get out of it. Now, if we rewind back to pre-2017, how the rules work, if you structured it perfectly fine and you got a 6% tax rate in Ireland, that's probably all you have to pay if you don't bring your profits back to the U.S. Right now, as Bert mentioned, the fund's being kind of taken out of the game because you'll at least have to pay a 13 to 14% rate no matter what you do as a U.S. company, unfortunately.
Yeah, but still better than the headline rate. There's still tax incentive for doing this kind of thing. So why don't we pause here? We've done case studies 1 and 2, similar fact patterns, slightly different. Any questions or comments from the audience that we could respond to? Yes, sir.
Question for Harnik. So are you then finding you're rewriting employee agreements with the company as relates to IP ownership that you were talking about, to either make them consistent or to reflect the proper kind of IP
We often
hierarchy?
do. So,
Yeah.
like, we get the employment agreements or consulting agreements. Often, like, we essentially just draft because majority of the consulting agreement relates to the IP and like ownership. But the employment agreement, definitely there is an intellectual property section. There's the trade secret section. So we'll get it. We'll add our relevant provisions and work with their the HR team and lawyers in-house.
Is it ever retroactive, or is it only going forward then in terms of any changes that are made?
Retroactive, as in like fixing past
If there
issues.
was past, yeah.
Then you have to do it manually, sort of thing. You have to go to each of your inventors and instead of the automatic assignment of rights, you have to get like specific assignment of rights. Like, you invented this, you assign it to this company, and so you have to do it for each one of the inventors. And the other comment I was going to make is that from a patent and IP perspective, it's often better if you have a single owner of the IP. Split ownership causes a lot of issues, and that's why in this particular fact pattern, we had all the IP rights go to the Irish company, but it could have been the US company. It's when you split ownership, that's when you get in trouble from a patent perspective that I think Lad's going to talk about in the future, in the next case scenarios.
Yeah, from a tax standpoint as well, split ownership just opens the situation up for tax authorities to come in and start recasting things and giving the taxpayer results that they don't necessarily want.
And there is an important distinction too for transfer pricing. There's a focus on economic rights in contrast to necessarily legal rights. So the contract might say one thing, but transfer pricing is going to look at what's actually happening in the business and the operations.
Okay, let's go to our next case study. This is case study 3. In case study 3, we've got Pizza Guys, Inc., a global pizza franchisor. They've developed an app for their customers' use in ordering meals for pickup or delivery, targeted marketing, and managing inventory. The franchisees pay a royalty based on app sales. And the thing we want to talk about here are some of the legal aspects of this. but also the characterization of income from the U.S. perspective. So let's start with Knobbe. What type of IP is typically implicated in this kind of an app?
Yeah, whenever you are opening up like any of your software app on your phone, there's a lot of IP that could be affiliated with it. For example, Taco Bell is one of our clients, and over the last several years we've been working with their app. I'm not sure if you've ordered from the Taco Bell app. It's actually pretty awesome. I order it quite frequently. It's there could be the trademark associated with it, right? Of course, Taco Bell's own trademark, but other trademarks that they have. Then we've tried to cover some of the app features through utility patents, how the data is being transferred to the server, or like when you're ordering something, does it automatically send signals to some machinery to start a process? So it could be utility patents. User interfaces, like what you actually see on your phone, we've been protecting a lot of user interfaces, any interesting features, the way you click or order. You could file design patents on the look and feel of your user interfaces, which many people don't think about filing design patents on user interfaces. There is, of course, copyrights in your software, and trade secrets like algorithms and ingredients. So there's a lot of IP rights that could be implicated with just a software application that's on your mobile phone.
A lot of other issues besides the IP planning with doing a project like this, from value-added tax to just country-specific requirements, rounding up to the nearest dollar, what have you. In any case, question for RSM, does IRS treat different types of IP rights the same? Is there any difference between trademark rights versus patent rights for tax purposes? Kenneth, maybe you could take that one.
Yeah, sure. So generally, IP rights are considered intangible assets from a tax perspective. So I would say on a general basis, the IRS has a similar view of how the treatments are, but there are specific code sections where specific IP rights are called out. For example, like trademark rights versus patents might be different, or sometimes goodwill, for example, could be differently treated from other types of IP rights as well. So I think the overarching the conclusion is that yes, they are fairly similar in nature on the tax treatment, but there are specific rules that could be different in the tax code.
Yeah. Okay. We'll get to substance over form in a minute, but Jamie, maybe you can answer this question for us. Are there any tax implications to consider when determining royalty rates over a period of time, such as 20 years, which is the typical term of a patent, so long-term license agreement?
So basically, a royalty is typically paid on a percentage of sales basis. And I think what's complicated about this is that there could be a characterization difference between whether this is considered a royalty or a service. And if it was a service, it would be based on a cost plus arrangement where you're looking at the costs were accumulated and charged out and markup applied.
Okay, thanks. Kenneth, we're talking about royalties here, but in the U.S., under U.S. tax law, we have this substance over form doctrine, and that's been formally embraced in the statute, regulations, and case law. Could you tell us a little bit about how the substance over form doctrine applies to royalties?
Sure. So substance over form, just as a general principle, basically says no matter what you label it from a legal or a business or even an accounting perspective, the tax rules or tax treatment for that specific item doesn't have to follow what you call it. If it's a service fee, but it's actually more like a royalty or vice versa, that's how the U.S. tax law would treat it. So in this particular instance here, even though these are called quote unquote royalties coming from your franchisees to the U.S. company, in this case, Big Pizza Guys, Inc., it could be treated as a royalty even from a foreign country perspective. But in the U.S., just because of the fact that a lot of these applications usually have some software as a service component to it, the US could treat this royalty as a service rather than a royalty. Now, why is that problematic? The main reason is that in a foreign country, royalties are subject to withholding taxes there. So, for example, if you've got a franchisee located in Switzerland, for example, Switzerland would impose a withholding tax on that royalty. Let's say it's $100. Switzerland imposes a 10% tax on it. So $10 gets paid to the Swiss government. Typically, if it's also called a royalty from a U.S. perspective or treated as a royalty from a U.S. perspective, you'll be able to use that $10 to offset your U.S. tax liability. But just because of the fact that the U.S. could view this particular arrangement as more of a software as a service, so basically as a service fee, what happens at the end of the day after applying the rules is that $10 would be in addition to your U.S. tax. So if your U.S. tax is 21%, of the 100, you'd be paying a double tax on it, right? A tax in Switzerland and a tax in the U.S. without any offsetting credits against each other.
Yeah. And that issue actually came out in Pizza Guys, which was one of our clients. They originally were planning on making the software resident on the franchisees' servers. So in country, royalty, claim foreign tax credit, everything works out. They subsequently decided to move everything to the cloud, and it transformed that royalty to a service from a U.S. perspective. And because the cloud was really managed from within the U.S. source service, no credits, so the client got whipsawed. So little details, little tiny details like that can make a big difference in terms of taxes. Okay, that's it for case study 3. Any questions or comments in case study 3? This characterization issue. Go ahead, Rob.
So as you were wrapping that up, did they end up paying in country a royalty or a service?
In-country service, or
Okay.
a royalty rather.
Royalty
Yeah, the
still,
country
okay.
looks at the license agreement and it's called a royalty. It looks and smells like a royalty to them. They
So
withhold
they got the 10% plus the.
plus the
21.
U.S. tax, essentially double tax.
Yeah.
Now, there's some treaty relief. So for some countries, there is some relief to avoid that double taxation, but for some countries, it's just the cost of doing business. But the best practice is to get the tax folks involved early as you're documenting, as you're developing your business model and drafting your agreements. So sometimes these tiny little differences really don't make a difference from a business standpoint. Easy to make a change, and they can trigger a much better tax result.
Yeah, and I think that's the takeaway from the scenario is just whenever you're working on any transaction with your franchisees or anything, think about like the corresponding tax or IP consequences. Like, for example, if you had worked with your franchisee that give me $5 for every app purchases, like in perpetuity, based on these patent rights, that would probably not be enforceable because patent rights are only for like 20 years. So after a 20-year term is done, you would have to have a slightly lower royalty payments instead of 5. It would have to go down to 3 maybe. But otherwise, you would be extending your patent term indefinitely. So due to public policy reasons, courts have not found it enforceable to keep the same royalty rates even after their term expires. So whenever you're thinking about these transactions, there's IP implications and tax implications, even though if you're just negotiating business to business.
Good comment.
It's striking that you could be making a technology decision like taking something up to the cloud and have no idea what kind of tax implications you're creating
Right.
for yourself.
Yeah.
Or perhaps legal as well.
And from another area that also has privacy implications,
Mhm.
we've been dealing with a lot of data privacy issues lately. California has its own law, GDPR in Europe, and where your data is in your servers, there is privacy implications as well.
Yeah. Okay. Anything else on case study 3 before we move on? All right, case study 4. This one's a little bit more complicated, so you have to bear with me. But this is really more real world. These are the kind of situations we more frequently see. So we've got 2 companies. Consumer Widgets is a U.S. company, and it purchases a Canadian Target, a company called B2B Widgets. So a U.S. company buys a Canadian Target company, now their parent subsidiary. Both companies have extensive R&D facilities on their respective sides of the border. There's substantial overlap in the technology. CWI wants to set up a holding company to own all the IP, including copyrights, trademarks, trade secrets, and patents in the US, Canada, and other countries. And both companies are going to transfer all their IP to that holding company. They're going to set up the holding company in Switzerland, which is where the CEO of Consumer Widgets lives. The holding company will grant an exclusive license in the field of consumer use of widgets to all this IP throughout the world to CWI, and an exclusive license in the field of B2B use of widgets of all the IP throughout the world to BWI. So both companies transfer the IP to Swiss, and Swiss licenses back to each country, respective field of use. The holding company will be capitalized with capital from CWI and BWI. The holding company will provide exclusive licenses to each company for fair market value of the IP. The holding company is going to set up an investment fund, the income from which it'll use to continue the operations of prosecuting and maintaining the IP of the two companies, as well as future enhancements and developments of the IP. And any enhancements to the IP will be transferred back to the CWI and BWI under similar terms. The consumer and business-to-business fields cover about 95% of the use of the widgets, but the other 5% has significant potential value. The holding company will have a technology transfer arm that will look for outside licensees of this other 5% of the rights. So the holding company, that Swiss company, is going to be looking to market that IP. The technology transfer effort will be funded from the income of the investment fund. However, any income received from the technology transfers will be distributed to BWI and CWI. So complex fact pattern here. So questions for the panel, and maybe we'd start with Knobbe. What do you need to implement this structure in terms of license agreements, employee agreements, and so forth?
Before we get to the what question, I just wanted to explain why. And these are the types of, this entire complication that Bert just explained. This does happen, and we do deal with situations like these. And the reason why is when you're having IP split across companies, and there is an opportunity, the company sees an opportunity to not only just utilize the IP for its own use, but to also monetize the IP, to license it out. It is often better to consolidate the IP with one entity, in this case, the holding company in Switzerland, so that the licensing arm could go and offer the would-be third-party licensees an efficient transaction, so to speak. So they wouldn't have to go and negotiate separately with CWI, BWI. You could have more subsidiaries, and this creates an efficiency for the would-be licensees and an opportunity for them to take a wholesale license, especially when IP is related. And that's just a nicer way to do business. There's a lot of examples like these. For example, on the patent side, there are a lot of these are called patent pools, and there's some very famous technologies are pooled, like DVD, the right to decode DVD. All DVD players for companies are licensed or should be licensed. If they're not licensed, then they would be sued under this patent pool called MPEG-LA. It's a pretty famous patent pool. So this is the reason why this is all set up. And now, of course, the question of what, and that it's pretty clear that we need agreements. So Harnik touched upon this for employment agreements, but we need more agreements here. The agreements that we need are to assign, to transfer the IP from the Canadian company and the US company to the Swiss holding company. So that has to be done correctly. IP has to be transferred correctly, and the holding company has to own all the rights to the IP. By the way, just to step back, what are exactly IP rights? Just let's just look at patent rights. And I remember from law school, I was taught that, and with Harnick, we were all taught the same thing, that patent rights are like a bundle of sticks. So patent carries the right, an owner of a patent has the right to practice, make, use, sell, import, offer to sell. And each of these rights is separate. So, and there's also the right to sue, of course. So each of these rights could be, parsed out. So if you wanted to, you could only offer someone the right to import or the right to sell, or if you keep all the rights to yourself, you could keep the right to sue. So the agreement has to be correctly done so that all the rights flow to the holding company, and the holding company becomes the owner of the IP. Then there is another agreement for the license back to the Canadian entity and the U.S. entity, and this also needs to be done right. The fact pattern mentions the word exclusive licensee. What does that mean? That means that the U.S. company and the Canadian company would have all the rights to the IP exclusive of anyone else. So in the field of consumer, which is where the U.S. Company would have rights, no one else can practice that IP in the field of consumer widgets. And then the third agreement that would need to be done is the agreement assigning all future IP to the holding company, because the fact pattern talks about continuing development on the Canadian and the U.S. side, and all of that IP has to go to the holding company. So there's an agreement there, and that implicates employment agreements and agreements that Harnick touched on, in agreements transferring IP between CWI, BWI to the holding company.
So Vlad, what happens if there's an infringer in the U.S.? What considerations should be taken into account to bring a lawsuit?
So when bringing a lawsuit, we as lawyers worry about, of course, there is a question of what can you get when you sue, and then that's the question of remedies, and that's pretty clear. But there's also a question that we as lawyers worry about that I'm not sure that a lot of lay people appreciate as much as we do, is who can actually sue, because there are legal doctrines and legal principles that have to. The technical term is called standing to sue, but what it really means is the party who can bring a lawsuit has to have enough vested interest in the subject matter of the lawsuit to even ask the court to resolve this dispute. And all of this stems from the fact that courts resolve actual disputes. If anyone ever listened to a Senate confirmation hearing for a Supreme Court justice, senators throw out a lot of questions. What would you do in this case? What would you do in this case? And a lot of answers are, I do not comment on hypothetical cases. I only comment on actual cases. So this is the same principle here. The idea is that courts want to resolve real controversies, not issue advisory opinions. And it has to do with use of judicial resources. If two parties have vested interest in a controversy, that means that they will use their, do everything possible to win a lawsuit. So this brings out, parties that are fighting hard against each other, and the real outcome that the court can help them reach. So that's called standing. And so what we would look for here is between these three entities, the holding company, Canadian company, and the U.S. company, who can actually sue. And this can get quite complicated on the legal side, but suffice to say that the holding company can always sue, because under these agreements that I discussed, they would own all the IP, and the owner of IP can always definitely sue. As far as whether the Canadian company and the U.S. company could sue in case of, for example, patents, that's debatable. It depends on, without going into specific, it depends on what their exclusive license is. If their exclusive license is in the field of, in a limited field of consumer widgets and business widgets, they cannot sue on their own, because the courts view that as not having enough sufficient vested interest in the lawsuit to bring suit on its own. So that's as far as standing. Now let's talk about what you can get out of the lawsuit. There's, lawsuits are expensive, and you want to, if you decide to bring a lawsuit, you want to be able to win something tangible. So in case of damages, let's say again in case of patents, there is an idea of collecting lost profits, and that could be a very powerful remedy. And of course, as the name suggests, it covers the would compensate the company for lost sales due to someone's infringing activity. So to get lost profits under U.S. law, you have to bring in a party that actually makes the sales. So in this case, the holding company on its own would not be able to collect lost profits because they don't make any sales. So you need to bring CWI and BWI, or at least one. Then another component of remedies is an injunction. Harnik talked about this a little bit when he talked about ITC and the function that they have to block importation of goods into the U.S. This is a similar idea, except that it doesn't really, it's not limited to importation of goods. It's just an idea that someone could be enjoined from selling. And this is a super powerful remedy, maybe even in many cases more powerful than collecting money, because if you just stop someone from being able to sell, then they're done, or at least as far as this product is concerned, they're done. So again, the idea here under U.S. law is that someone who actually makes sales can bring or can seek an injunction. So again, the holding company would not be able to do that on its own. It would need to bring one of CWR or BWR.
Maybe you can tell us a little bit about the transfer pricing for this. And let's start with the outbound transfers of the consumer and the B2B IP from U.S. and Canada.
So principally, you have to value the IP that it's being moved from Canada and U.S. to Switzerland, and the valuation is based on the long-term cash flows that can be received. And as U.S. and Canada are making sales and performing services on behalf of Switzerland, it's important to make sure that Canada and U.S. are getting reimbursed for the services that it's performing. To the extent that it's making sales and it's owned by Switzerland, again, a royalty might be in place. But the transfer pricing is going to be focused on the functions, the risks, and the assets of each entity. And for me, that there could be a concern to the extent that if there isn't enough substance in Switzerland, if there's only one person there or what have you. So it's very important that who's ever holding the IP, that they have plenty of substance. Again, perform the important DMP functions: development, enhancement, maintenance, protection, exploitation. So the profit would be allocated within the group based on those particular functions.
And in this case, the CEO, important guy in the organization, sits in Switzerland. He's going to be raising funds to develop the IP and then marketing that 5%, which we think has real potential. So based on that, do you think there's a basis for allocating significant profit to Switzerland? So the guy in Switzerland, the CEO, important guy in the organization, maybe the founder, maybe the creative genius behind the technology, he's going to be raising funds. He's going to set up an investment fund to fund the future development of the IP. And then he's also going to be leading the marketing of the IP outside of the field of use. We've already talked about B2B and consumers, that 5% of the IP that has significant potential value. So the question is kind of a leading question, but I would think we'd be able to allocate some significant profit to Switzerland based on those DMP functions.
Yeah, absolutely. Because there's no rule that basically says if you have to have one person or 5 people or 10 people performing those DMP functions. it's all based on facts and circumstances. It'd be very important that when you're talking to a client or a company to ensure that that person really is performing all those particular functions and having that support. For transfer pricing, a lot of these transactions are very heavily documented. And there's an interview process that you can speak with companies just to confirm that these facts and circumstances are occurring.
The documentation is important too. In the U.S. and many jurisdictions, there's a contemporaneous documentation rule, which means you need your transfer pricing documentation in place before you file your tax return. And the reason for that is they don't want taxpayers doing backfill, filing the return and then figuring out what the transfer pricing is after the fact with the benefit of hindsight. So contemporaneous documentation is really the only way to avoid transfer pricing penalties in the U.S. And most of our clients do annual transfer pricing for that reason. Yeah. So this is a more complex fact pattern. Takeaways on this one: global profits, we slice up the pie based on the Dempy functions, and just the importance of the facts and the details, the devils in the details when it comes to these kinds of things. And questions, comments from the audience? Yes.
Is your industry overall one of the ones kind of growing and booming right now? Because I would think there's so much need for all of your expertise with technology and all the new companies and global, everybody. How easy it is to work across borders.
Yeah, business is good.
And how often, part two, how often are you coming in to fix stuff versus you're there from the beginning consulting, working with people when they start?
Did you guys go first?
Fixing most of the time.
I figured.
It's mostly with startups. They'll just start and they'll get a consultant for if they're making like a wearable device, right? Like okay, let me get a design consultant and let me get this person, and they'll just sign whatever they'll have to sign to get things moving without thinking about the appropriate agreements and clauses in their agreements. So we're going back and renegotiating those agreements now because we need that IP provision in there. And now it's much more valuable because if you don't have it, you're not going to get the investment in your investment round, like Series A, B, C diligence. So yeah, we're fixing things in our sometimes Series D diligence, like things that were done like at the start, at the very founding thing.
For us, it's a combination of the two. Typically, the clients that we end up fixing really are the ones who they started out small, they weren't international. Typically work with a very, very small local firm, just your typical mom and pop shop. They come to us, and then they realize they've done a lot of these things without consulting their tax advisor about doing them. So I'd say that's probably about 30 to 40% of the case. But for tax at least, this is why we actually do like working on our clients' tax returns as well. Because right from the beginning, when they've started growing and they've just started being domestic, at least we have a good feel of what their global landscape looks like. We have a good feel of their business fact pattern. So along the way, they will consult us when these things actually happen. So which is why we usually prefer clients that are, for tax purposes at least, we're preparing their tax returns and doing any kind of IP planning, any kind of global planning as well. That way we can keep an eye as well for them when they're trying to go at 100 miles per hour. We're like, hold on, gotta go at 40 miles per hour first, and then maybe slowly go to 100 miles per hour.
It's important too that the tax structure should fit around the operations. You don't want the operations to fit around the tax structure. So focusing on the business is number one. The tax should be a layer on the outside, and that should be tweaked. But again, based on how the operations are set up.
That's been a big change. I mean, 15 years ago, you'd see these crazy structures that were driven by tax departments. And the rest of the firm would kind of get in line behind the tax department to drive the tax benefits. That's not the way we operate anymore. It really needs to be driven by the operations people, the strategy people, and the lawyers.
Sorry, go ahead.
Yeah, just a question from sort of a mindfulness perspective that you're seeing in the market. What percentage are sort of forward-looking and dotting all the I's and T's beforehand versus the after the fact? Like, would the majority sway one way or the other? sort of that knee jerk of, oh, we should have had this implemented, long ago. We're leaving money on the table because we're not set up properly from a tax, from an IP or otherwise standpoint, or I'm sure it's across the board, but just sort of from a macro perspective, are you seeing more pre-set up right and thinking ahead, or more, oops, we better get on this now?
It's there are so some of the organizations are helping. Like there are a lot of incubators, right, for startups, and if you're part of incubator, like in Orange County, there's Octane. That then you have a network of or of mentors essentially who will tell you that you make sure you get this and this like lined up. So I feel like we are seeing more sophisticated startups who at least think about like contacting an IP lawyer early on. But we'll still, like I said, even with like companies who are much in a later stage, we'll see they're trying to move so fast that's where they trip up. Like they're signing these agreements, they're making all these like whether it's sales or like royalty decisions without really thinking through all of the consequences. So it's the speed that creates a lot of the issues. Just trying to get things done the next day.
Yeah, and same thing from a tax perspective. Usually for startup companies, the owners are typically, or the founders are typically very gung-ho about getting things done. We're paying so much taxes, let's do something about it right now. And then we come in maybe a couple years after they've done something. And it's actually usually the other way around. When they've implemented a structure, thought that there's a bunch of tax benefits associated, we're like, actually, hold on, looking at the tax rules, it doesn't work that way. Now we can help them get there, but there's obviously more work that needs to get done. So I'd say it's a mix between both. But I generally think in terms of tax planning and legal planning too, the people who consult their tax advisors and attorneys early usually are the winners at the end of the day. I mean, you could implement something tomorrow, it might look good, but then it's not really good if a couple of years from now it's got to get struck down for whatever reason, or you're getting all these queries from the IRS, the last people you want to deal with when you're a startup company.
Yeah, so multifaceted, and it's amazing to hear just like even the implication on business model, right? Subscription versus sort of how you're structuring the product and the revenue stream.
Yeah. I'll say it's a really interesting area to be practicing in now, just because things are changing so fast. It seems every day there's a new business model walking in the door, and it's like, what is this? How do we even treat this for tax purposes? Rob, you had a question?
Yeah, Harnik, you made a comment earlier about companies potentially protecting the look and feel, user experience, design, that sort of thing. Could you maybe talk about the pros and cons and whether there's good value in doing that?
I mean, there's definitely good value in it. I don't know if you remember like the famous Apple versus Samsung cases, and they were on the user interface design patents, the slide to unlock.
Yep.
So that I think that case really put design patents on the map. Before people used to file design patents, not as many, and they were mostly on physical aspects, like the shape of a lamp, for example, or something like that. But in software, it's tricky to protect different aspects of software with utility patents. And oftentimes it's really hard to figure out if somebody's actually infringing what you're doing. So you have an app and you might see like outwardly they're doing this X, Y, and Z functions. How they're doing it, you have to somehow reverse engineer the code, which could be encrypted. It's next to impossible. But user interfaces, you can see exactly what they're doing, and it's often driven by what customers want. So if a customer really likes the slide to unlock feature, somebody else is going to copy that feature. So we have noticed corporations for example, I think Apple does a really good job at protecting all their user interaction features, because that's really where it's easy to see if somebody else is infringing, and it's going to be like the first thing that someone will likely be copying.
Mm-hmm. And like you say, easier than reverse engineering. the
Easier than
software.
reverse engineering algorithms.
There's also a question of term. We mentioned a few times that utility patent term of 20 years, that's typically utility patent term. And that's 20 years from the filing date. For design patents advantages, it's 14 years, 15 years,
Yeah.
15 years from the issuance date. So hypothetically speaking, if you have enough different designs in your design patent application, you could extend that patent term out for decades and decades and decades.
What strikes me though, when a patent expires, that's a pretty material event in terms of what implications could be for tax and legal, work. How far in advance, when you know your patent library and when things are going to expire, should you be starting to look at what are the implications when this is no longer protected under a patent?
Well, I think you would look at that up front. If you're moving those IP rights offshore, for example, you look at that 20-year life and valuing the IP rights. That would be your
It's already
term.
factored in.
Yeah.
Yeah.
So, yeah, keep that account up front. Would you agree?
Dynamic are the laws regarding transfer pricing overall? Is it a changing environment or is it pretty static?
So the good thing is that the at least the methods that we use for transfer pricing are pretty uniform. So to the extent that we're doing analysis here in the U.S. and it's affecting, say, both the U.S. and Canada, it will be a method that's accepted on both sides. That makes the transfer pricing a bit easier. What does vary from country to country is documentation requirements. Each country has its own triggers, its own penalties. That part can get very complicated, and you really need a big network of people to be able to make to organize that. And so we work a lot with our international colleagues, just coordinating. And it's important, with transfer pricing, there's always at least two sides of the transaction. I think, companies are usually too focused on, say, just one side, the U.S. or Canada, what have you. So it's important to make sure that you are looking at both sides of the transactions, looking at all of the implications, VAT, customs, other indirect taxes that might be impacted.
There are a couple of countries that are outliers. They don't really buy into the global transfer pricing regime. Brazil and India are the first to come to mind. You think a little bit differently, and it sometimes creates some conflict.